Batson v. Kentucky deals with the prosecutor's use of peremptory challenge in criminal cases. But first, some background. In the United States, you have the right of a jury of your peers to decide your criminal case. If you are accused of a crime, a jury will be assembled of the people in the community who will listen to the case and decide whether you are guilty or innocent. Let's hear a hip hip hurrah for the Bill of Rights. The process of selecting a jury before a trial begins is called voir dire, or to speak the truth. Here, a large group of people are called to the courthouse by a writ of venire facias, may you cause to come, and, in smaller groups, called back to be questioned by the attorneys from both sides of the case before a judge. The attorney who represents the party accusing another is called the prosecutor, while the one representing the accused party is the defense. The attorneys use this process to determine who will best be able to serve as a juror on the case. Now that that's out of the way, let's get to the juicy stuff you've been waiting for, the facts. The year is 1982. James Batson, who is black, has been charged with receiving stolen goods and second-degree burglary. This isn't Batson's first rodeo with the law. He's broken it before, and he's been to court before as well, and he assumes that the lack of witnesses and evidence placing him at the scene of the crime will lead to an easy win in court. It doesn't. Batson is convicted of both charges by an all-white jury. It turns out that during the jury selection, the prosecutor used his peremptory challenges to strike 4 black people that were called from the jury. Batson appeals his case, arguing that the juries in his community were being unfairly selected and did not represent it accurately. He challenges the prosecutor's actions, saying that the removal of the black jurors violated his Sixth Amendment right to an impartial jury of his peers, along with the Equal Protection Clause of the 14th Amendment. He is granted a writ of cert in 1985 by the U.S. Supreme Court. Batson's litigators used the case of Swain v. Alabama, where the court recognized that a state's purposeful or deliberate denial to Negroes on account of race of participation as jurors in the administration of justice violates the Equal Protection Clause, and Strouder v. West Virginia, where the court invalidated a state statute that provided that only white men could serve as jurors. The opposition argued that the precedent set by Swain v. Alabama and Strouder v. West Virginia did not apply to Batson's case, and that his constitutional rights were being upheld. The Supreme Court ruled that the prosecutor's actions violated the Sixth and 14th Amendments to the Constitution. The majority held that racial discrimination in the selection of jurors not only deprives the accused of important rights during a trial, but also is devastating to the community at large because it undermines public confidence in the fairness of the justice system. Without identifying a neutral reason why the 4 blacks should have been excluded from the jury, the prosecutor's actions were found unconstitutional. In the end, Batson v. Kentucky has set a precedent for checking the constitutionality of peremptory challenges. But racial bias in jury selection still hasn't been completely stopped. Studies from as recent as 2015 show potential jurors who are black were much more likely to be struck from the juries than non-black. So I want to pose this question to you. What makes a jury of peers? And has that definition of peers provided an opportunity for too much bias?